And as you're getting ready, our next court for the morning is Ortiz versus Smith-Walker. I understand each counsel would like to stay seated at the table. We'll be fine today for our arguments. I would ask you, when you're doing that, please make sure you do speak loudly so that you can be picked up by the recording here that we're having today. If you're referring to any children, minors, or victims, please make sure you refer to them by initials. I don't know if this is relevant in this case, but if you were to have that, please do so. Of course, each part about 50 minutes presents their argument. Counsel, would you like to save some time for rebuttal?
Yes, Your Honor, I'd like to save 2 minutes.
2 minutes for rebuttal. The court will take note of that. And again, the court will attempt to remind you to get closer to that, you know, your time if that would happen. We've read your brief and are ready to proceed whenever you want.
Thank you, Your Honor. Your Honor, I represent the Edgar Ortiz and Gila Mercado, who have 2 children and are living in the property that they purchased from Adrian Taylor. And originally, before the gentleman died, he had a company that Adrian Taylor ran for him. It was a real estate company, and it was a ministry. And there was a contract entered into with him, and my clients made every payment obligated under that contract. At his death, Adrian Taylor became the executor of the estate. In that process, Adrian Taylor filed an inventory with the court, and in that inventory referenced the fact that this real estate was a part of the estate, and referenced the fact that this contract existed and monies were being collected. Over the course of time, my clients paid off the contract that was represented to the probate court in an inventory as being paid in full. And I believe that at that point, my clients should have been entitled to a deed from the property. For whatever reason, that was not accomplished. Mr. Rosenbaum's client then sought at some point to file an eviction against them to throw them out of the house. And that's when they came to my office, and I filed something with the court, the complaint asking with the attached exhibits, the contract, the series of payments to show that it was reduced to 0, where we could get a deed from the probate court. And it was obviously fought by the new executor after Miss Adrian Taylor was removed. And both parties filed motions for judgment on the pleadings under Civil Rule 12C. And in the process of determining that, the trial court, said that, well, the Mercados, Ortiz Mercado, despite the fact that they paid it in full, that they gave no benefit to the estate. And despite the fact that Adrian Taylor had admitted that they were paid in full, clearly there's a issue of fact. And I think when I look at what the judge had done under the resolution of the 12C motions in his discussion, I think he entered into fact-finding improperly, determined that my clients had no interest in the house. And so therefore we had to file this appeal. Because they paid for the house, they live in that house with their 2 children, they're entitled to the home. And I would say to the court too, that before they actually moved into that house, they bought the house when it was in I don't want to say deplorable, but it was more of a fixer-upper than it was in a livable condition. And so they rented a house that the ministry had very close, and they lived there and paid rent and paid auto rent until they were able to save up enough money to fix the house that they moved into. And so the house that they live in now, as improved by them through their sweat equity, is certainly to them much more than the $18,500 sale price that they purchased this house.
The proceeds of the $18,500 that they paid,
Yes, Your Honor.
Do the records of the estate show they were paid into the estate?
Well, that is exactly, the inventory shows these assets, both the real estate and the contract, as being assets of the estate. And Adrian Taylor has admitted, you know, that they were paid in full, that the 18.5 was paid in full.
Did those assets, those payments go into some estate account at some point in time where the estate had received $18,500?
The estate has received 18.5. What account Adrian Taylor put them into, Your Honor, I cannot say. I cannot
Well,
say.
the account, have there been, I presume, formal parts of accounting filed in the state?
Yes, Your Honor.
Executors say, I received X amount of dollars from so-and-so.
Yes, Your Honor. Adrian Taylor, I believe at the time, was represented by attorney Spike. What's Alan's son's name? I'm trying to remember.
Well, I mean,
Neil Spike was representing him. I'm sorry, I'm getting old. And Neil filed an inventory, okay, and he also filed a partial account, I believe, and it reflected the fact that these monies and this contract existed. And to that, Your Honor, Mr. Rosenbaum's client, Mr. Rosenbaum filed an exception to those documents because he said that the real estate and the monies received would have to be put into the estate. So he acknowledged at the time that he filed his exemption that this real estate belonged as an asset of the estate, and that those monies and proceeds collected from my clients are estate funds, and he was demanding that they be accounted for. Now, I understand in my discussions, and it's very clear from the court's declarations, that Judge Walther believes that Adrian Taylor is a very deceptive person, and that everybody's going to lose here unless Adrian comes up and puts money back into this estate. Your Honor, I have no control over Adrian Taylor. I have no control over that at all. However, she did acknowledge that my clients had a contract with the estate. Now, originally it wasn't, but she ratified it by saying, yeah, we're going to sell it to you. And it's all been put in the inventory, it's all been put in that account. And she acknowledged that my clients paid in full. And in fact, attached to...
When you say she ratified,
Yes.
how specifically did she do that? Is there a document somewhere we can review it through testimony, or how do we know she ratified?
The document that you would view, Your Honor, is the inventory that was filed. She recognized that this contract was an asset of the estate, and that she was collecting money on it.
Prior to the time the inventory was filed, had your client paid all the money to Ms. Taylor for the property?
All that was due. Through the date of his death, they had paid all the money that was due. Then subsequently to his death, they continued to make the payments in accordance with the schedule, which, Your Honor, by the way, is attached to the Mercado complaint, Ortiz Mercado complaint. And it delineates all the payments that were made until it's down to zero. And I believe it was on March 9th that they paid the last payment on. And
March 9th of what year, do you know?
yes, I do.
If you do, and if you don't, we can check it record.
I believe it was 2021.
Okay.
I believe.
We'll review the record for that, thank you.
And what's important, Your Honor, to know is that I really believe this is important because I think there's an estoppel feature here. You know, Mr. Rosenbaum's client, on May 2nd, 2019, he filed exceptions, okay? And in those exceptions 5, item 5 and 6, he talks about the fact that this real estate needed to be included, and the proceeds from the sale needed to be included, okay? But now today, and in his briefing, he says there was explanations to the judge. He says there's no contract. But hold on, he declared that there was a contract, and that the money from that contract belonged in the estate, which we agree 100% to. But he can't come back now, later, and say, hey, I don't care what I said before to the court. It isn't that way at all. There's no legal contract here, even though he said there should have been, even though the monies should have been recorded to the estate. So I believe that's an estoppel He can't have it both ways. And when I look back to what Judge Walther has said, and I don't need to belabor that, you can see it, he doesn't really trust Adrian Taylor as far as he could throw her, okay? That's very evident. But my clients are not guilty of any fraud here. My clients did nothing but work and pay the contract that they had with the decedent, and as recognized. So the court should have, in my argument and opinion, should have issued a deed. Should have said, hey, you guys paid it in full, here it is, here's your deed, judicial deed. Whether the new executor wants to give it to you or not, you're entitled to it, because you paid the contract in full. And I think when you look at the 12C standard for judgment on the pleadings, okay, and the judge even talks about that, when he says, maybe what I should do is deny both motions and then ask for, have a hearing, have evidence submitted. Well, we wouldn't be here today if he had done that, but he found against my clients who paid in full for their home. And now, they're sitting here worried that they're going to be evicted, despite the fact that they bought the home, paid for it in full. And it's just, there's something wrong about that, and the fact that Adrian Taylor is distrusted, by the probate court judge, who, honestly, he's condemned her as basically dishonest and wouldn't trust her, and, I don't have to go into that, it's all in the brief and the transcript. But the point is that my clients are innocent of any of the theft that Mr. Rosenbaum and Judge Walther apparently believe Adrian Taylor committed. So that, it puts us in a position where, Adrian Taylor, through her lawyers, filed to demonstrate to the court that this real estate was a part of the estate, and that the contract dealing with that real estate was a contract that was being performed.
Did she reference the land contract in the inventory in any way?
Yes, she did, Your Honor. In fact, if you go to the docket, you will see a schedule of assets that show the real estate, and you will also see, or it talks about the contract and the payments from the contract, and it's there. It's in the docket. And Judge Walther said he was going to review his docket, and if he had, Your Honor, you respectfully say that had he done that, he would have seen these.
Hey, Counsel, you have about a minute of time left in your first time.
Oh, okay. Like Judge Walther says, to somebody who I would consider as a fraudster, and that's Adrian Taylor. The judge believes Adrian Taylor is a fraudster. Not my clients. My clients paid money.
Were there any legal deficiency with the contract, the so-called contract?
If there were, Your Honor, they would have been cured by the ratification of the executor filing, saying, hey, look, this contract exists, and I recognize it. I'm not going to say that I, as an attorney at law, would have written what was written for my clients, okay? But it was sufficient enough to identify the property, identify the terms, and partial performance existed. In fact, total performance. And when my clients paid off the mortgage, Adrian Taylor was still executor. So,
You're now in your rebuttal.
yes, Your Honor.
Thank you.
Thank you.
You're welcome, Your Honor.
Good morning. My name is Jonathan Rosenbaum. It's my honor to appear before you on behalf of the executor in this case. Mr. Gargas plays fast and loose with the facts, and I think his answers were somewhat deceptive to the questions he posed today. But before I get into that, I want to make a couple of corrections. On page 1 of my brief, I have the wrong date for when my client was appointed. She was appointed on April 27th of 2016. I also have the wrong date for when the will contest action was filed. It was August 2nd of 2018. As Mr. Gargas said, this case arises from a contract which he tries to enforce, what he calls a contract for the Jesse Matthews, this contract with deed did not come into existence, if that's what it is, until May 20th of 2017. Mr. Matthews died on July 4th of 2016. There's no evidence whatsoever in the record to support 99% of what Mr. Gargis has said happened today. The inventory that was filed in this case, as the probate court specifically found, listed this property as an asset of the estate. It made no mention of any contract for deed, any contract, any installment contract, in any way, shape, or form. When I objected to the inventory and list of assets, I pointed out that through discovery, this contract existed, but I referred to it as an illegal sale. At no time did anyone who was the executor of this estate purport to ratify or claim that this contract existed as an asset of the estate, and that includes Adrian Taylor. And I guess I want to point out that my client was first appointed as executor under a long-standing will that arose in 2011. Adrian Taylor obtained a deathbed will through attorney's Spike, which was later thrown out. When Adrian Taylor brought that deathbed will to court, she was then appointed. All of these actions occurred before she was appointed. The statutes are very clear that any action taken by a person that does not preserve the assets of the estate or pay the funeral bills prior to your appointment is null and void. So at best, Adrian Taylor's actions, when she became the executor for a brief period of time, were null and void. But again, I can't emphasize enough that the court found, and you can read in the record, that the inventory filed by Adrian Taylor acknowledged that this property was an asset of the state. Not that it was being sold, not that the contract for sale of the land installment contract was an asset for the state. Mr. Gargis is just wrong when he says to the contrary. He is also wrong when he said that Adrian Taylor was doing business under some kind of LLC that Mr. Matthews had during his lifetime. JLM Enterprises LLC, which is the party that supposedly sold this property, with Adrian Taylor acting as the manager, has never existed and does not exist. After Jesse Matthews died, 2 years after Jesse Matthews died, as a result of things that I found on behalf of my client, Adrian Taylor created an LLC that purports to be a charity that was something like Jesse B. Matthews Enterprises in his service ministry. That LLC is not a party to this land installment contract and did not exist at the time the land installment contract ended. There was no doubt that Adrian Taylor is a criminal and probably has scammed these people. But I couldn't sell your house as a criminal and then expect you to give the deed up to it later, even if they did pay for it. And there's no evidence in the record that they paid for it, no proof positive whatsoever.
And is there any evidence that whatever proceeds were received by Ms. Taylor were deposited in estate accounts at any time?
The evidence is to the contrary. As my brief points out, there was never an estate account. Adrian Taylor, not that it's really relevant to this proceeding because it's not in the record, but Adrian Taylor tried to create a bogus charity to accomplish the goals of her second bogus will. Then it became apparent in the hearing in which Mr. Gargis was not involved that she thought she could be the charity and appropriated all these monies and funds to her own use. They're lost to the estate and everything else. But there never was an estate account. There never was any of this money paid to any estate account. And if it were paid to Adrian Taylor, who sold this property not on behalf of the estate as the contract that they're trying to affirm or assert or ratify claims, it was to her benefit only, and and that's where the money went. Now, as the trial court properly found, in deciding whether to grant judgment on the pleadings in this case, they found this was an installment contract for the sale of land. The complaint concedes that, and he found, as you asked, that there were many, many defects which rendered this contract unenforceable. The first of that defect was there was no legal description. The second was it did not contain the principal balance. The third was there was not a definite due date that the installments were due. The fourth was that there was not a provision that there should be a general warranty deed. No deed was ever granted in this case. Mr. Garza's clients received no deed. It did not go through escrow. They did nothing whatsoever to check the title history of this to see if they were even buying this property from someone that owned it, which they weren't. They violated the law of caveat emptor, which applies in this case, as I cite in my brief. They didn't file a copy of the contract with the recorder as required. So if there's any latches or estoppel, it's all on their behalf. The contractor for deed did not comply with the formalities of a land installment contract. No deed was ever issued. The jurats are empty, they're not sworn before a notary. And finally, the contract for deed was not timely presented to the estate as a claim against the estate.
On that issue, did you make the argument at the trial court that this was not a timely claim against the estate?
Absolutely.
I know the judge did not rule on that issue. That was something you addressed to the trial court.
Absolutely. Yes. The judge didn't see fit to get to that. I really don't understand why, but it wasn't brought timely before the court. It wasn't brought till 2 years after his death. And finally, the trial court ruled that there was no contract for deed that was enforceable because it was a contract between private parties and not the estate. I mean, and the contract that he asserts says so. You know, he wants the estate to remedy their unfortunate lack of due diligence in any way, shape, or form that's required of a purchaser in a real estate deal. So basically, the trial court properly held, based on the evidence before the court, that there was no way that they could succeed. Now, Mr. Gargas has made many sympathetic arguments today and wants to, say that these people are wronged. I don't doubt that they were wrong, but those arguments aren't before the court. He tried to get them into the record improperly, and this court refused to permit him to do so. So as it stands, based on the pleading that they filed and the documents they attached, there is no cause of action that can be found that they could possibly concede on, construing those documents and any inference properly drawn from them. And they have to lose as a matter of law. And we ask that this court affirm the trial court's judgment, because had they done one thing on their behalf, as the law of caveat emptor requires, they would have realized that Adrienne Taylor is the fraud that she is. And again, I argue, if I wrongfully sold your property to these people, and they didn't check, they didn't get a deed, they didn't see if you even owned it, if I owned it to sell your property, you don't have to remedy them for their own malfeasance. And that's what they're asking for. So we submit the trial court acted properly. Thank you.
Thank you. Do I use full time for rebuttal, counsel?
Thank you. Your Honor, the flaws in Mr. Rosenbaum's argument is the fact that the court approved the inventory, showing that the real estate was a part of the inventory, and it also acknowledged that the contractual payments that Mr. Rosenbaum is demanding need to be provided into the estate accounting. Now, you can't have an estate asset being sold by an executor of the estate ratified by her accepting of all the payments, and not find that my clients had an interest in the real estate. This isn't a claim against the estate. This is a purchase agreement that they fulfilled. And at this point, they're entitled to a deed. And when we look at the complaint and the answer and all of the attachments that is supposed to be reviewed by the trial court under a 12C analysis, there was no basis for the ruling that he made. He entered into something that he was weighing the evidence, as is very obvious how he feels about Adrian Taylor. And my clients should not be completely left with nothing after all their sweat, equity, and money that they've deposited and paid for this real estate. So I'm asking this court, either send it back to the trial court for a further hearing and a trial, or order that Mr. Rosenbaum's client issue a deed, fiduciary deed, to my clients who have paid for this property. Thank you.
Thank you, Counsel. And thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course. The court will mail a copy of that decision to you on the day's release, and it'll also be released in the High Supreme Court website at that time. Thank you both for your presentation.